who are, all right, got it. So just a quick show of hands, how many have attended at least one, if not both parts of the HOA legal issues workshop before? See Tom. Everybody else has their screens black. So, all right. Well, if you haven't done these before, the way it works is I have a bunch of slides that I like to cover. There'll be some variation in the topics just because this is an interactive workshop in that I have materials and information that I want to present, but people come to these with questions and you're encouraged to ask those questions. I may cover it in either today's part or Thursday's part. And if so, I'll just tell you, all right, we'll cover that later. But invariably, there's a question that will kind of take a rabbit trail and we'll cover. Very quickly, though, this is for information, educational purposes. There's no attorney-client relationship created. This is not the kind of information that you would want to rely on as legal advice. The reason is each fact pattern, each set of covenants, each circumstances are unique. And the way proper legal advice works is your attorney needs to understand all of the facts, circumstances, the governing document language. So the purpose of this workshop is to get us into a ballpark, okay? There's some important concepts. There's some recurring themes that are important for anyone, whether you're a board member, an officer, a professional providing services to an Oklahoma homeowners association or condo association. And those are the things that we're talking about tonight. So use the chat feature in Zoom. If you have a question, you can type that in there and then we'll get to it. There are some other resources available out there. For example, we record these Zooms. We've been doing them for 15 years. Of course, we don't have 15 years of Zooms, but there are a number of these videos that are on a YouTube channel. You can get to that by going to YouTube, searching Winton Law. You can go to my blog, which is at okhoa.blogs.com. A lot of resources out there. All right, so let's dive in. This is a roughly a 2-hour program. I pretty much talk nonstop for the 2 hours. There's no intermission. If you need to get up and get a beverage or something like that, feel free to do so. All right, so we start from the very beginning with this, and that's with kind of fleshing out the development process, the various what I call governing documents, the contracts, agreements, instruments, things that get filed with the county clerk's office, with the Secretary of State's office, the things that set out the rights, responsibilities of property owners, occupants of homes within a community association, the board's responsibilities and rights and powers, and then the association. So what are those documents? Well, here's a list of some of those documents that we at least need to be familiar with. If you're on the board of an association, it's a really good idea to have a 3-ring binder. And if not a hard copy, you have electronic copies that you have in a folder or a file, if not on Facebook or in a share file. But having a governing documents file organized, because a lot of the questions, a lot of the topics that come up. So for example, it's a real common question in corporate governance, community associations that are incorporated, to ask the question, well, what's our quorum? What's the minimum number of people that we have to have in a room, either in person or by proxy, in order to conduct business? Well, the declaration or the covenants might answer that. The certificate of incorporation might answer that, but oftentimes the bylaws will answer that question. And we need to know what that language is. All right. So the plat, if you don't know what a plat looks like, this is what a plat looks like. It's actually a legal description. And under the law, it's what allows us to refer to a piece of real estate as Lot 1, Block 1. This is a plat of Lakes at Bridgewater, which is a platted residential community in Oklahoma County, happens to be in the city of Edmond. And a plat's going to answer some really important questions, not just how many lots are in the development, but also what common areas are platted in the addition. It won't necessarily tell us if the association owns those common areas. That more than likely will be answered by a filed deed, but it will tell us what common areas there are. Also importantly, if you can't read this, but that language that I'm highlighting, this fuzzy jumbled word right here is notes. It's real common for a plat to have a notes section. Now that notes section oftentimes will tell us whether we have a mandatory association or a voluntary association. It might tell us what limitations for construction within certain easements. So there could be a wealth of information. Now, I don't know if we have anybody who is in Tulsa County or on the eastern side of the state. But if so, you not only will have the plat, but there will also be 2 or 3 more pages attached to the plat that are called deeds of dedication. Now, those are oftentimes substantive covenants, and they will go into more detail than the Oklahoma County and the Western County practice of just filing notes and then a completely separate set of covenants. But this is what a plat looks like. And this is what starts the development. And so it's really important. So for example, if a question is, does this particular lot owner owe dues? Are they a mandatory member of the association? Well, we don't jump right into the covenants to answer that question. What we do is we find the plat, we find the date when that was filed, and then we have to determine, okay, was this lot that we have a question about, was it transferred subject to any covenants? So usually in a timeline, we have the day one, the plat's filed, and then the same day or immediately after, we have a set of covenants that gets filed. And then only after we have both of those things in place, then do we have lots transferred. Now, if we have some kind of mix up, or if somebody gets a little antsy and we have plat and then a lot sold, and then we have covenants filed, well, now we have an issue because we have lots that have been transferred out that aren't subject to covenants. Now, that's a fixable problem. It's a completely avoidable problem. We can avoid that by making sure we get covenants filed. But that's a question. That's something that the board needs to determine, from the outset, and having a well-organized, well-researched set of governing documents. We can clear that off our list so that we know all of the individuals that we're sending dues invoices to are subject to covenants. So question comes in, does the plat need to be refiled once all lots are sold? No, actually, once the plat is filed, that is the survey for the neighborhood. Now, interestingly enough, so you'll see up at the top here, I don't know if you can read that or not, but this plat that we're looking at, it says replat of Lakes at Bridgewater. What that means is we had an original plat, and then for some reason, and I don't remember what the replat was on this one, sometimes we will have a replat to reallocate some lot lines. We might have, so on this one, this is a very large common area. If you can see my cursor, it's a wet pond. And so maybe the original plan was we had lots down here, and for whatever reason, floodplain or something, it didn't work out. And so we replat that into common area. But no, once the lots are sold, we usually consider the plat fixed. Don't typically see a replat or a modification of the plat. That would be atypical. So now we do see modifications of covenants fairly regularly. And we're going to talk a bit about covenant amendments in more detail in part 2 later this week, but not a whole lot of modifications of the plat. All right, so let's talk about the development process. Talked a little bit about it just a second ago. So we have a piece of dirt, real estate. The developer will get that zoned to whatever the ultimate use is. If it's in a municipality like Oklahoma City, Tulsa, Mustang, Newcastle, any municipality, they're going to have ordinances that govern the subdivision or the zoning of land. So the developer will follow that. That's usually where the platting process comes in. Plats are approved and reviewed by the municipality, their planning department. So it's not just something that the developer comes up with and then they file it. It's often a conversation or at least a compliance with whatever the particular municipality, their zoning or subdivision regulations are. That gets filed. There's nothing that says the association has to be incorporated. Okay, there's nothing under the law that says it has to be incorporated. But one of the things that I want you to do, write this down or make a mental note, from a practical standpoint, from a liability limitation standpoint, all of our HOA and condo associations should be incorporated. There's really no good reason not to incorporate it. So when a developer comes to me and says, hey, we've got this new development coming online, we're 2 weeks away from the plat being filed, I use that as a trigger to go ahead and get the association incorporated. We don't wait till the plat's filed necessarily. We don't wait till the covenants are filed necessarily, although we could, but we like to have that HOA entity or condo entity incorporated sooner rather than later. So whenever that happens in the process, it's not so material as what we talked about, the plat and the covenants being filed. That is material. We have to make sure, again, that we don't get any lots transferred out that aren't subject to the covenants. So we file the plat, we file the covenants, and you see this phrase here, constructive notice. One of the main reasons why we want the covenants filed of record before any person takes title to a lot is because of constructive notice. So what constructive notice is, it's a legal fiction, basically something that we just make up because it's convenient for us, but it helps us in day-to-day life. If the covenants are on file, then whenever a property is transferred that is subject to those covenants, we don't ever have to wonder whether this person actually got a copy of the covenants. We don't ever have to wonder whether they were told there was going to be a homeowners association. Sometimes in collections, sometimes in covenant enforcement issues, when the association sends a notice or maybe our firm sends a demand letter, what comes back from the other party, the other person is, well, I was told there wasn't any covenants, or I was told there wasn't a homeowners association. Well, that may be true. It's just not legally effective if the covenants were on file when they took title. So what constructive notice is, it's kind of like the school zone analogy. If I'm speeding in a school zone, I still get the school zone ticket, even if I had no idea it was a school zone. Now, officer may have discretion to show me some leniency, but he or she doesn't have to, okay? So that's what constructive notice does for us, and that's why it's important to get the covenants on file prior to any lots being sold to consumers. Now, at some point, the developer is going to be done with developing. Either they will have put in all of the streets, they would have put in all of the intended common area improvements, whether it's just a green belt or it's detention areas, even a splash pad, swimming pool, recreation, clubhouse, all of that stuff. At some point, the developer is going to be done and they need to transition the control of the association to the resident owners, to the lot owners. In some states, this is a highly formalized process, meaning there's statutes or laws that say when the developer has to do this. That is not true in Oklahoma. So oftentimes what you hear is, well, when the developer sells 75% of their lots, they have to transition. That's not true in Oklahoma. The only way that would be true in Oklahoma is if there are covenants filed for that particular development that expressly state the developer has to transition at 75. And that's not very often. In fact, the documents that I prepare for developer clients, they don't ever have a percentage. It's essentially whenever the developer feels like it's time, then they will initiate that transition process. And what that looks like is usually developer or their lawyer or somebody calling a meeting and answering questions, doing this transition of control, of management, and ultimately there being an election of the HOA or the condo board. The developer appointed or developer elected board or officers resign, and the lot owners stage their own election. And then at that point, they control the association. Sometime around this period of transition, now again, this is kind of like with incorporation of the association. There's nothing that says the transition can't happen or shouldn't happen or doesn't happen until the common areas are transferred over. Sometimes the common areas are deeded over to the association before any lots are even sold. So if you've got one platted common area, it's a little green belt, well, there's no improvements, there's no reason to wait. The developer may go ahead and transition or deed that over to the association. It may be that a sufficient number of lots have been sold and have houses constructed on them, and the common areas haven't been fully improved yet. So if there's clubhouse, swimming pool, developer may not have completed that when it comes time for transition. So there's really no magic number or time period. It's kind of a, well, we will feel when it's time. Either the developer feeling like, okay, it's now time for us to get out of the HOA management business, or the lot owners approach the developer and say, sometimes it's time for you to get out of the HOA management business, or we're ready to take it over. So however that happens, hopefully it's a peaceful, non-chaotic process, oftentimes led by the developer, initiated by the developer, and that makes sense. They're the ones that started the process. They really need to have their hand on the wheel and guide that transition process. And that's one way that developers can help their customers get their association up on the right foot. And then from that point on, in perpetuity, forever, the association will be managed by the board of directors, its officers, or by third-party managers. Okay. All right, so let's talk a little bit about what the law is in Oklahoma. There's not a whole lot of it. If you've done your research into statutes, you would know that there's only a handful. Now, there's sometimes confusion on what applies to what situation. So I've used this term a couple of times, HOA and condo, but let me take a moment to tell you exactly what I mean when I use those terms, just so that we're speaking clearly, because it makes a big difference about the law that we refer to. So in Oklahoma, if you go to Title 60, Section 501, and this et sec just means and continuing. So this Title 60, Section 5, starting at 501, going through about 530, is the Oklahoma Condominium Act. Now, you won't find that term in the act. It won't say Condo Act. What it'll say is Unit Ownership Estate, which is a very old way of referring to condos. Oklahoma has a first-generation Condo Act. It's never been amended or updated since the late 60s. It should be. I would hope that the legislature would do that sometime in my career, but we'll see. But this is the Condo Act. This applies to a condominium form of ownership. Now, condo does not refer to a type of structure. So the room that I'm sitting in could be a condo. You could condo an entire building. You could condo an entire city block. Condo doesn't refer to the structure. It refers to the type of ownership. And it's a common framework of ownership, meaning the association or possibly the unit owners in undivided interest own whatever the exterior of the condo regime is, and the unit owner typically owns airspace and then maybe the final finishes of a room or a building. And you just have to read the governing documents to know. So one of the common questions, either because of a roof leak or a plumbing leak, is who's responsible for what? The governing documents to the condo will answer that question. Hopefully, they were well drafted and they'll answer that question. But usually, most of the time, the folks that are on these workshops are going to be dealing with HOAs. But not necessarily so. If you have a condo question, we're certainly open to discussing that as well. But the HOA Act starts at Title 60, Section 851, and goes through 858. This is not called the HOA Act, which HOA is just a very easy abbreviation. It's a common abbreviation for homeowners association. So whenever I use HOA, that's what I'm referring to. But Section 851 is the start of what's called the Real Estate Development Act, often called REDA, R-E-D-A for short. And this is the very brief, this is bare bones law on homeowners associations. You won't find a whole lot of answers there. About the only thing it answers is, okay, what's the bare minimum to create an HOA in Oklahoma? Can the HOA file liens for non-payment of assessments? Can they foreclose on those liens? Can we collect attorney's fees when we have to enforce the rights, responsibilities, use structural restrictions found in covenants? So it answers those very general questions. But whether it's a condo or a HOA, almost all of our questions are going to have to come from, or the answers to our questions are going to have to come from the governing documents themselves. So it's very important that we have an accurate set, meaning a file stamp set, not something that somebody just handed out, not a retyped version that somebody put on the internet that we've been using for decades. And I find that way too often, that someone, an association board or an individual lot owner or unit owner comes and says, hey, I've got this question, here's the covenants, and what they hand me are not covenants at all. It's something somebody created that you can't rely on. So that's another reason to have a very good set, a reliable set of governing documents, because our statutes don't answer a lot of those questions for us. And then lastly, this is Title 18 and a couple of statutory references. So Title 18 is where the Corporations Code, the Corporations Act is found. Once again, if your association is not incorporated, I strongly suggest that you find a means to incorporate it. It's not expensive, it's not complicated, and the benefits, particularly under this highlighted section, 18 OS 865, 866, and 867, and then that 1001 is where the Corporation Code actually starts. You have a wealth of protections as an HOA or a condo board and officer, and it gives us some minimum operating guidelines. So for example, and we have a slide on this later we'll talk about, but so for example, if you find yourself in an association that doesn't have a set of bylaws, or for some reason the bylaws don't have a quorum provision, if your association is incorporated, then the Corporations Act will supply a quorum, which, like we mentioned, quorum is important because it provides the minimum number of people, either in person or by proxy, in order to conduct business. So fairly important provision. Where can you look at all this stuff as opposed to just taking my word for it? You can go on the internet and go to www.oscn.net. That stands for Oklahoma State Courts Network. All of Oklahoma's law, whether it's the statutes we just referenced, cases, all of the Attorney General's opinions, professional rules, district court rules, all of that is free and online. So Oklahoma does a really good job of making the law freely available to everyone, and that's where you would find it. All right, a couple of things just to be aware of in Oklahoma City. Other municipalities may have similar ordinances. If you're not familiar with ordinances, ordinances work like statutes. It's in the level of governance at the very bottom for your associations, you have covenants. Those are the rules, regulations, the laws, so to speak, for your neighborhood. And then above that, you're going to have whatever city or county you're in, there will be ordinances that apply to the use or structures on your properties. Now, they may not be exclusive. They may not exclude application of your covenants. So, for example, there may be a public street in your neighborhood, and there are ordinances that provide certain rules for parking on public streets, and there may be a covenant for your neighborhood that prohibits street parking. Well, the fact that it's a public street and ordinances allow it doesn't exclude the enforcement of that covenant that says no street parking, okay? But in the same vein, if there's something that the law says can't be prohibited, then covenants can't trump that. An example of that is we looked at the real estate, we talked about the Real Estate Development Act. If you go to Title 60, Section 858, there's a statute that is a mirror of a federal statute that talks about flying the American flag. So, for example, if there's a covenant, just hypothetically, that says under no circumstances can any member fly an American flag in their front yard, that would be absolutely unenforceable because state statute and federal statute say you can do that. All right. By the way, I keep hearing that that there is an Oklahoma statute that says homeowners associations can't prohibit or limit solar panels. There has been some discussion at the state federal level in years past, but unless it snuck past me, I'm not aware of any state statute. I think where that's coming from are solar panel sales companies that are trying to increase their sales, but not aware of a state statute that expressly allows or requires the installation of solar panels. There are in other states, like Arizona has that, but not Oklahoma. Anyway, so back to this slide, Oklahoma City has an ordinance that deals with home sharing, basically Airbnb, VRBO. If you're within the city of Oklahoma City limits, you either, and you're going to home share, you either have to comply with this ordinance or you have to be in violation of this ordinance. Now, this creates a problem for people who want to be Airbnb or VRBO landlords if you're in a neighborhood that has covenants that, one, expressly limit leasing, or two, prohibit businesses or prohibit nuisances. So if you're in a neighborhood that has covenants that prohibit business use, which almost all sets of covenants in residential areas do, and almost all sets of covenants have some kind of clause that says no noxious or offensive activity shall be conducted in the neighborhood or anything that is a nuisance to the neighborhood. So if you are operating a Airbnb or a home share, as defined by Oklahoma City ordinance, you're operating a business. You have to get a business license. You pay business taxes. Well, that's a business under the covenants. And then if you decide, well, I'm not going to get the business license because I don't have to pay the tax or whatever, well, then violation of an ordinance is also defined as a nuisance. So it's exceedingly difficult to operate a home share business in a residential neighborhood in Oklahoma City because of this ordinance and comply with your covenants. So that's something to pay attention to. Backyard chickens is a big deal as well in various cities, and virtually every set of covenants in most residential developments have some kind of animals, pets, livestock restriction. So this would be an example where you have an ordinance that says you can do something, but covenants may still restrict them. So the fact that a city has said, we are allowing you to do this under ordinance, again, doesn't necessarily mean you can do it under your covenants. All right.
Can I ask a question?
Yeah, sure.
What about prohibiting certain breeds of dogs?
So that's kind of a hot topic. Anecdotally, it's known that certain breeds of dogs are more aggressive than others. And so, but it's difficult to prove that scientifically. So typically what you will see, rather than restricting on the basis of breed, you restrict on size, you try to define aggressive. So focusing on behaviors as opposed to breeds is what you try to do. I can't tell you that prohibiting a certain breed would be unenforceable. It's just we look for more reliable definitions than no pit bulls, no other commonly understood to be aggressive breeds.
One of the things that we were advised was that we could require that the homeowner have, I'm sorry, my voice is really bad today. That the homeowner have a specific insurance policy to cover that dog.
That's a new one to me. I didn't know that there were insurance products available to insure specific types of dogs.
There aren't, but that's
okay. All right.
That's the way you get around it. So that's what we were told to do. So I just don't know if we have a leg to stand on. We're just trying to do what we need to do.
Yeah. So typically with animals, what we do is we focus on behaviors as opposed to breeds. So for example, all animals shall be retained within the house or the yard securely. If they're outside of the yard, they shall be under the control of the owner. And then putting in gradually, because we have to provide due process, a system of, okay, if someone just decides they're not going to follow the rule, they're going to endanger others, particularly if they have one of those dogs that you have to keep an eye on. Then you've got the language in place to deal with the behaviors as opposed to the animal. All right. Very quickly, I'm going to do my best to scare the pants off of you and once again convince you that your association needs to be incorporated. So whenever you have an unincorporated association, what that means is you have two or more people collecting other people's money and then spending it on something other than just those people's property. I mean, that is the definition of an association function, is you accumulate shared money and then you spend it on some shared goal, but never on private property. Well, when you do that, each individual person who is a member of the unincorporated association is individually liable for the debts and the liabilities of that association. So nightmare scenario, you have a private road, the association is tasked under the covenants with maintaining that road. There's a pothole, somebody comes in to visit someone else, they hit the pothole, their car rolls over and they're severely injured. If your association is unincorporated, each of the individual members of that association are personally liable for whatever that potential liability is. So there's no reason in the world to operate that way. This is why we incorporate. We have the association as the owner of the common areas, particularly areas like private roads, and that's the customary, the favored way of operating as an association. If you have no idea whether your association is incorporated or not, you can look at old tax returns for the association, assuming that they have filed taxes. That's another topic we'll get into in a little bit. You can go to the Oklahoma Secretary of State's website. They have a business entity search. It kind of begs the question, well, if I don't know if we're incorporated, what do I know to search for? You oftentimes will search the name of your addition. If you have a set of covenants, a well-drafted set of covenants will have a definition section, and that definition section should tell you the name of the incorporated association. Now, here's the thing. If you have covenants and it has a definition section, and it says the association is Happy Acres Property Owners Association, comma, INC, period, that doesn't mean your association's incorporated. It just means somebody thought, I'm going to name the association this, I'm going to define it in the covenants, but we still have to do the extra step of actually incorporating it with the Secretary of State. Filing covenants does not create a corporate entity. Covenants are filed with the county clerk's office, wherever the neighborhood sits, and articles of incorporation are filed with the Oklahoma Secretary of State's office. Okay, we're going to get into some nuts and bolts of association operations, and I spend a lot of time in meetings. I was in a meeting in South Oklahoma City last night. I'll be in one tomorrow night, and I mean, it's hours and hours of meetings. And so there's certain things that I've observed, and I hear repeated frustrations. One of those is our meetings are very long and very boring. Well, there's a great book by a medical doctor named Atul Gawande, and it's the name of the book is called Checklist Manifesto. And I encourage you to read it, but if you don't want to read it, I can tell you the entire premise in about 30 seconds. Its checklists work really, really well. They work well for medical doctors to fight off infection. They work really well for airline pilots not crashing our planes. And guess what? They work really well for HOA boards as well. So for the HOA board, the meeting checklist is called an agenda. Doesn't have to be fancy, doesn't take a lot of time. It's just a list of, okay, what are we going to cover in this meeting? What do we need to cover? What's open, and what maybe we can have a little time to talk about. Maybe if this is a board meeting, we could have a time period for lot owners to give us feedback, because technically under corporate governance, a board meeting is not for the lot owners or members to show up and spend all of our time griping about something or telling us what the board is doing poorly or even doing well. It's a board meeting. The purpose of a board meeting is for the board to conduct business. Now, it's a good idea to have a time period where lot owners can express feedback. Otherwise, they feel like perhaps they're getting shut out, but they're not to be involved in the deliberative process. And so one of the things that I find, if a board is having very long meetings, if they're getting worn out and seems like they're not getting a whole lot done, the two things to look at is, are you following an agenda, and are you allowing lot owners or members to basically run your board meeting? And if so, maybe putting in some guidelines or rules or adopting an agenda practice so that our meetings are down to 1 hour, an hour and a half, maybe longer, depending on what we're talking about. if you need. But 4-hour board meetings, that should never happen. I mean, that is way too long for a board meeting. Okay. All right. A couple of other things to consider, and this is under the annual meetings. Think about the environment and the demographic of your neighborhood. So if you have a neighborhood that has a lot of families with young children, ask the question, all right, how can we make this environment more conducive, more welcoming to families with children? And I'll tell you, saying out loud, look, if you bring your children and they're throwing a fit or they're disruptive, that's perfectly fine. I mean, just using the terms to put parents at ease so that they don't have to apologize for a 3-year-old acting like a 3-year-old. I mean, that's part of what the association can do really well, and it doesn't cost anything, is helping people feel more at home. And that's really the purpose of a community association. In fact, it occurs to me, Anna, I need to make a slide on this. I can't believe I haven't, but the purpose of an association is not to tell people what they can and can't do with their property. The purpose of an association is not to take people's money and punish them when they don't pay it on time and in the full amount. Those might be functions of an association on occasion, but they need to be the exception. The rule for our association is this thing promotes community. It helps people feel more at home. And that, even if it's in a small way, if you can make parents feel welcome at annual meetings, then figure out a way to do it. It works the opposite. If your demographic skews older, less mobile, well, then pick a location that's easy to get to. Coordinate transportation. Thinking in terms of how is our association providing customer service. Now, I know a lot of people, when they go to these workshops or you talk to an attorney, it's okay, how do we enforce this? How do we have our covenants have teeth? And those are appropriate conversations, and we're going to cover enforcement. But what I found is if we're doing the customer service part as best we can, then the collections, the enforcement, that becomes even smaller. When people are disgruntled, when they don't have good information, when they feel like the board is there just to punish people, that's where we see a rise in disgruntlement, in withholding dues, and ignoring covenants. So thinking in terms of how does our association provide customer service, that's a great question for your board to ponder. One of the comments came in, if we have an annual meeting with residents, do we have to open our monthly meeting to residents? You don't have to, no. But this actually is a great question, good timely question. It dovetails into what I'm talking about. So it's not necessarily so that if you exclude residents from the board meeting that people will automatically suspect that the board's up to no good and that you're hiding something. But what an owner can't do is accuse us of hiding something if they're free to come to the board meetings. Now, more than likely, they're not going to come. They don't come to the annual meetings where they actually can vote. Why are they going to come to the board meeting if they can't vote? Well, oftentimes it's to complain about something or to disrupt. And that's where we need to kindly, gently, and then maybe increasingly more firm, educate this person on what their role is at the board meeting. Okay, you're free to come. We encourage you to come. We have a lot of work to do, and us allowing you to be here is not a green light for you to shout from your seat, for you to raise your hand, for us to call on you. I mean, this isn't a classroom. This is a board meeting, and that's why having an agenda, it's a real easy thing, particularly for board members if they're not used to running meetings. if they're a little bit reticent on telling people, now look, hold on, we'll get to you later in the section. An agenda really helps because we can put it at the very bottom, open floor for member comments. So when the person just can't help themselves and they're, hey, okay, I see you. It sounds like you've got something to say. We'll get to you when we get to the end of the agenda. And then if a person, it also helps the board establish whether this is, we're dealing with reasonableness, or if we're dealing with someone who, it doesn't matter what the rules are, it doesn't matter what the game is, they're going to make up their own rules, they're a law unto themselves. Well, we'll give people an opportunity to either be educated, to calm down, but at some point, if a person has simply demonstrated, I'm going to do whatever I want to do, well, then I don't need to wait till the end of the agenda. I have my answer from you, and we're just going to exclude you. And if a person can't demonstrate that they can behave in an adult fashion, then they get excluded. Referring to the role of the association, which includes I'm not sure I understand. The comment says, and maintains the values of the community. It was referring to the role of the association, which also includes maintaining the value of the community. I'm not sure I'm tracking with the question. Sometimes there's language in covenants that says the board shall maintain the common areas and operate in a first-class manner or something like that. What that language tries to do is establish a something more than the minimum, if that makes sense. So boards are elected and are vested with a very wide amount of discretion. And the fact that an individual believes the board isn't operating it in a first-class manner doesn't mean the board is shirking their duty or violating a covenant. It simply oftentimes means that there's a difference of opinion. Now, if there's years of deferred maintenance, or we get to something that demonstrably the board has not discharged its duty, well, then maybe that would violate first-class manner or something like that. But the fact that there's a difference of opinion on level of maintenance, that's kind of par for the course, where you have individuals vested with making their best guess, their best choice. But what the law does not require is a board to respond to every demand from individual owners. And there's a couple more comments here that are helpful. Thank you for sending that. So for example, trash cans is one of the comments. Is the board shirking their duty because they don't have an iron fist on trash cans? No, they're not. So this is a lot like where you have a covenant that says no noxious or offensive activity, and an individual's neighbor's dog is driving them crazy. And oftentimes this comes into the board as an email that says, board, my neighbor's dog is driving them crazy. What are you going to do about it? Well, the appropriate response from that board is, lot owner, we're going to help you as necessary to get ready to go have a conversation with your neighbor. That's what we're going to do about it. We're not going to go have a conversation with your neighbor because it's not the association's issue. Now, trash cans are a lot like that. And I know a lot of you are going to disagree with this, but the alternative is engaging my law firm to file a lawsuit for thousands and thousands of dollars for someone to take their trash can back. When oftentimes, if the neighbor will go talk to their neighbor and find out why the trash can's not being pulled back, or if I come home from work and my neighbor's trash can's out just like mine is, and they haven't gotten to it yet, I pull it back right after I pull mine back. Those little things, you're not taking on that individual lot owner's responsibility for pulling their trash can. You're not saying it's okay that you didn't do it. You're just picking up their slack. Maybe you do it once, maybe you do it a couple times, and then finally they do it themselves. Or finally you find out that they're using their trash can as a form of protest. Sometimes in collections cases, we find a person not paying their association dues because they're hacked off about something their neighbor's doing. Well, they still owe the dues. They've made a really dumb choice and a poor form of protest. But this is where our associations, we need to take a bent on, okay, how do we provide a customer service response before we get to the enforcement response? We can always enforce the covenants. The lawyer is always available for you to hire us to do the work. That's what we do. But in a community association setting, what we try to do first is figure out, okay, is this an enforcement issue? Is this an education issue? Is this an opportunity for the board to demonstrate leadership and have a conversation with this individual or the neighbor to help them go talk to their neighbor? The associations that at least ask that question, if not practice it really well, those are pumping incredible value into their neighborhoods. They pay less attorney's fees. They have a higher level of community satisfaction if we were to poll their neighbors. You don't see people blowing each other up on Nextdoor and Facebook in those neighborhoods. It really is one of the best enforcement techniques is to treat people the way you want to be treated. It saves a ton on attorney's fees. So, but speaking of hostility and chaos and dispute resolution, if you know that you're going to have a hostile meeting, if you think that this is just going to be, a barn burner of an annual meeting, hold it in a place where people tend to be on better behavior. Church sanctuaries, elementary school cafeterias or libraries, or in particular libraries, because an elementary, because the tables are small, the urinals, well, in the men's room, I don't know about the ladies' room, but in the men's room, the fixtures are tiny. I mean, it's hard to act like a big man in a little chair in an elementary school library. Okay, so a lot of times we will try to structure the location to tamp down on sometimes people's bad behavior. Real quickly, and then we'll move on. Sometimes you hear demands, or I have come into my office emails from board members that says, hey, we have a member telling us we have to comply with the Open Meeting Act, Open Records Act. They absolutely do not apply to condo and homeowners associations. Okay, if you read the act, there's no way these acts could apply to a homeowners association or a condo association. So don't let anybody tell you differently. So let me check there's a question about providing customer service using a management company as a buffer between owner, board, and or tenant. You have to make sure that the manager is equipped to do that. And that just means interviewing the manager and making sure they're going to provide the level of customer service that the board expects and is paying for. But the problem is, and it's interesting you use the word tenant. People generally think that tenants don't treat property the way an owner treats property. Again, I think that's anecdotally true. It's not empirically or scientifically true, but we have this idea. It works the same way with management companies. Management companies don't live in your neighborhood. They are not the literal neighbor that the board member is to the lot owner. And so oftentimes they're not going to have that customer service. And I would ask the question, if a board member feels like they need a buffer between their customer, between the board and the lot owner, ask the question, what are we trying to buffer? If it's contact, if it's dispute resolution, well, really that's the work that the board is elected to do. If what we're wanting to buffer is records requests, well, then absolutely, that's something, those kind of administrative tasks, that's exactly what a manager should do. It's like, hey, I sent my check in, it hasn't cleared yet. Can you tell me what the status of my account is? That's not board business, that's manager business. Now, if you don't have a management company, that's the treasurer's business, that's their job. But asking the question, okay, what are we buffering? What are we trying to distance ourselves from? Is it the servant work, the customer service work that a board is tasked with doing or should be doing? Or is it this administrative, not really busy work, but the stuff that you've hired the manager to ask those questions? That's really what the management company should do. So I want to talk briefly about resolutions. So as a lawyer that goes to trial to enforce covenants or defend against claims that are brought against board members or their associations, the corporate records are very important. And this is another area that I see a couple of things in my practice. One, I see board minutes or corporate minutes, whether it's board meeting or annual meeting, I see them as almost like transcripts where people are writing down, or they've recorded and then they've gone back and retyped the transcript. You know, Joe said this and then so-and-so did that. And then there was a comment from, I couldn't remember who it was or didn't get their name down, you know, just this novel of information. That's not a meeting minute. That's not what you want. And that's one way that board secretaries are really going to get worn out. Meeting minutes are the bare facts of the business that was conducted. So meeting minutes, they tell us when the meeting was, where it was. It tells us whether we had a quorum. If they're board meeting minutes, it tells us which board members were present, which ones were absent. And it tells us whether notice was sent or whether it was waived. And if it was waived, how. If there were any consents in lieu of meeting, in other words, if there was unanimous board decisions made by email or group me or text, it's going to record those. And then it's going to go into the laundry list of if there were officer reports, and then attaching those officer reports. If there was a bid process, notes that and includes the bid copies. And then it's going to have motion, whether there was second, and then what the motion actually was and whether it was approved or denied. And then there's an adjournment. So the reason we don't want all of this back and forth, in addition to it wearing out the person that's taking notes, is when it comes time to determine what happened at that meeting, we don't want all of the chit chat. We just want the bare motion, if it passed, and clearly articulated what the motion was. Now, this is important because if there's a question about whether something was done or was not done in court, those meeting minutes are called prima facie evidence. And what that means is if we have the meeting minutes, then we can look at them and assume, it's a presumption, we can presume that whatever those meeting minutes say, that's what happened. Now, it's a rebuttable presumption, meaning if I have written meeting minutes and it says XYZ happened, but there's a verifiable video or audio recording that says no, XYZ didn't happen, ABC happened. Well, we can use that video or audio to rebut the presumption of the meeting minutes. But for the most part, having meeting minutes, and we keep those forever, they don't ever go away, like, you know, contracts or insurance copies from 7 or so years ago. we keep the meeting minutes in perpetuity. So for example, I had a case earlier this fall in a county in Oklahoma, district court litigation, and the topic was whether an individual was a member of the association. Well, this association had been around since early 70s. And in order to demonstrate that the idea of this development all along for the last 50 years was that this individual and people similarly situated were part of the association, I went back and I got all of those meeting minutes, and they had pretty much intact meeting minutes going back to the early 70s. So it was very helpful to prove this question. So you just never know when meeting minutes become important, and having them available is a good idea. All right, so let's see. Violations like trash, lawn care, the board doesn't want to be blamed. They can call out the manager who's enforcing the covenants on their behalf. Well, number one, the board makes the decision to enforce covenants. No management company has the discretion to decide when covenants are enforced. That is always the board's decision. Now, you could have a board set a manager loose to enforce covenants. That's probably not a great policy. You don't want an auto enforcement policy. Once again, because the manager isn't going to address those situations or those neighbors like a board will. So just again, to be clear, management companies are there not to do the board's discretion or deciding for the board. If a person doesn't want to have discretion as a board member, they're in the wrong position. That is the definition of a board member. It's the buck stops with them. And so, for example, if a lot owner feels like a manager is out of line or has the facts wrong, they should always have a mechanism, the ability to go to a board and appeal, if you want to use that phrase, or simply have a conversation. So the board makes the decisions, they implement the policy, and sometimes managers implement that policy. But particularly when it comes to covenant enforcement and definitely collections, the board needs to keep its hand firmly on the wheel and not think that the manager can do that for them. In fact, at a certain point, the manager is practicing law as opposed to practicing management, and the board needs to be very, very careful of getting into those situations. So next question, do owners have a right to see minutes at will? You had me until the words at will. They do not have this at will, I demand it now, let me see it right now. They do not have that right. Now, lot owners and board members have very expansive records review rights. And I do have a slide on this later. We'll go ahead and talk about it. But it's not I fire an email off at midnight on Monday and demand to see all the books and records by 9 a.m. the next day. It doesn't work that way. It also doesn't work where you have individual owner firing off all these email questions. Well, why did the board do this? And what's the board going to do about that? The board has absolutely no obligation to answer every single question that comes off somebody's mind in the middle of the night or even the middle of the day. The board also doesn't have the obligation to create reports or create records on the demand of an individual lot owner. So in Oklahoma, the expansive records rights, it's an inspection and copying right. Now what I'm telling you is based on statute. You'd have to look at your bylaws. Sometimes covenants, not very often in covenants, it's mostly bylaws, will provide some kind of records inspection. And you'd have to look and see. Oftentimes what it says is the lot owners or members will have the right to inspect the books and records during business hours, during reasonable business hours upon so many days' notice. And that's kind of how the state statute works. State statute is Title 18, Section 1065. What that says is if an individual, it calls them shareholders, but it's talking about members of the corporate association, if they make a certain written request, and the written request is not an email sent to the board or their manager. Most of the time we don't require formality, once again, because the goal of the association is customer service. You know, if somebody says, hey, can I get a P&L? Can I get a balance sheet? Did we file a tax return last year? If so, can I get a copy of it? Most of the time we have all of that in electronic format, and the first one to see it, to get to it, they just email that on to the individual. That's good customer service. There's no reason to make someone file a 1065 request, you know, which has to be under oath. It has to state the proper purpose, has to give their name, address, all this formality. Really, the only time we snap to formality is if we think somebody's being cute, if we think someone is using their records rights to try to run a board ragged. At that point, usually what we'll do is we'll tell them, okay, we will respond as soon as you make a proper request, and may even refer them to the statute. If they make a proper request, then what we'll tell them is, okay, all of the books and records will be available at my office on such and such date. You're welcome to come, inspect, identify what copies you want. We will get a quote for the copies. Once you pay for those copies, then we will provide them. But again, if we're doing that kind of formality, we've got someone who who's playing games. And it's not that we're playing games, but look, we all have busy lives. We have other things to do, and we're not going to allow someone leniency under the corporate formalities if they're just getting their kicks. So we don't use it to punish people, but we do use it to require formality if someone's just messing us around. How long should bank records of the association's spending be kept? You're going to find differences of opinion on this. I think 7 years on bank statements. So in terms of the categories, 7 years on tax returns, bank statements, insurance policies, maybe contracts, and indefinitely on meeting minutes, corporate resolutions, having a permanent governing document file. That's kind of usually the breakdown. 7 years, you might hear some people say 5 years. I think 7 years is a better, more safe than sorry. Okay. I think I said everything that I wanted to on meeting minutes. I mentioned this earlier. And by the way, I will put all of these slides on my blog, and this recording of this workshop, both part 1 and then Thursday's part 2, will eventually be on the blog and also on YouTube. So you will have access to these slides. So don't worry if you didn't get something down, they'll be available. This slide, I'm not going to go into a lot of detail. Just know that this is another one of those benefits if your association's incorporated, that there are certain default procedural rules. We call them UOPs, which stands for unless otherwise provided. So this is one of those legalese phrases that you read in contracts and statutes that says, unless something else applies, we're going to do this. And that's what the corporations code does, is if your association's incorporated and you don't have bylaws, or the bylaws don't state it, or the articles of incorporation don't state it, well, then we're going to provide you some really helpful basic information, voting, percentages, quorum, things like that. I've mentioned quorum. Quorum is a minimum number of people that you need to conduct business. Don't panic if it seems like your association has not had a quorum ever. That is a real common occurrence, and most of the time things just continue along. If it becomes an issue, there are techniques to try to get a quorum. The easiest way is whatever your covenant, or excuse me, your bylaw quorum requirement is, you can get a proxy. So proxies are a piece of paper, an email, a text message, anything that indicates you want to give someone your right, your authority as a member of the association to be counted for quorum purposes and possibly to vote or how to vote. Okay, that's what a proxy does. Basically is something indicating, look, I don't want to show up to this meeting. I'm going to send so-and-so and they're going to serve as my proxy. Don't let anyone ever tell you that a proxy has to be notarized. If I have a client or someone come in and tell me their association or someone's telling them that the proxy has to be notarized, that is an immediate red flag that someone is trying to retain control, and I become suspicious. I mean, we should have a system that makes it more easy to participate, not harder to participate in our community associations. Board members aren't getting paid, officers aren't getting paid, the individual lot owners aren't getting paid. The only people who get paid to deal with HOA stuff is the manager and the lawyer, maybe the CPA if you're having them do some work. So this idea of you have to jump through some stringent hoops in order to get your proxy validated, that's a problem. It's a red flag and something that we need to look at and try to fix. So I cite the statutes that deal with proxies if you want to look those up. Most of the time, proxies are going to fall into one of several categories. It's going to be the blank check proxy. I give so-and-so my proxy to serve as my attorney in fact for quorum and voting purposes. I mean, that's the blank check. I want you to show up, you vote however you think, however you want, even if it's something you didn't think I would want, you've got my authority. There's something called a directed proxy. I give you my proxy to appear at the meeting, serve for quorum purposes, and vote as I've directed. Okay, that's a limited proxy. It's possible to give a proxy that is good only for quorum purposes. I want the meeting to have a chance of being conducted, which that's what quorum does, but I don't want it. I don't want my proxy voted. So that would also be a form of limited proxy. Okay. So very, very briefly on voting. And again, what we're doing is we're starting from the premise of how do we increase participation? How do we make participation easier? Maybe enjoyable is too high a bar for homeowners associations, but if you can figure out how to make it enjoyable, then do so. I know food trucks make just about everything more enjoyable. And so, you know, having food trucks, having raffles, having childcare, whatever, having the ability for people to appear or at least attend and listen, whether it's a board meeting or an annual meeting through Zoom, we all should be fairly familiar enough after enduring the last 2 years. I mean, I know all of y'all are, you're on here, but people are fairly familiar with online meetings and providing them the opportunity to participate. I think you're going to see a higher level of interest or at least participation in some of the meetings. This really doesn't have anything to do with meetings or electronic voting. I just kind of stuck it in here because we're talking about electronic things. So one of my dreads as a litigator, particularly when I represent the association, is when it comes time to get all of the text messages, the emails, the WhatsApp, message strings from board members. Now, let me paint you a picture the way this works. So you have an individual who asks a lot of questions, and questions are fine. But this person, they're going overboard, they're getting more aggressive, more animated, and they're becoming obnoxious. And now it's hard to not question their motives. It's so aggressive. Now it seems like they're just getting kicks, or they're playing games, or they're just doing it to be mean. This is the time sometimes when we're inclined to use language, possibly even in a joking manner, if not in all seriousness, because we think our communications are private. And at that point, they are private because we're not putting them on the internet in terms of a public sphere. But when it comes to litigation, so for example, this individual starts doing spite covenant violations, leaving the trash can out, kicking their trash can over, parking a semi in their front yard, whatever. If it's this same individual and we end up having to enforce, well, through the discovery process, all of those emails, all of those text messages, they're going to be handed over to the other side. And what we don't want is, we don't want our jokes or our comments to be misconstrued in litigation. And you can guarantee they're going to be construed in the worst possible light. So things that we call each other, maybe out of jest or just out of frustration, those are going to come to light, and they have the potential to really bite us in litigation. So the newspaper rule, whatever you call it, you kiss your mother with that mouth kind of analogy, whatever helps you before you commit it to writing, and that writing includes your text messages and emails. We got to think about, okay, do we want a judge or a jury to ever read this? Is there a possibility that they'll misconstrue this, or that it's going to come back to haunt me or the association? Well, then just don't send it. Okay, that's the point of the newspaper rule, and just watching what we say. All right, here's some FAQs. I'm not going to cover all of these, but several of these come up, and they're just kind of random questions that you may be wondering, or it's important to at least have the concepts. I'm going to go to the bottom first. This Class A, Class B, and what is a declarant? So it's real common in covenants to distinguish between the developer entity and the rights, the responsibilities that the developer has, and the rights, responsibilities that regular lot owners have. And oftentimes what we'll do is we will define the developer as declarant, and we'll also call them the Class B member. So, and then on the converse, the regular members, the lot owners, the occupant owners, they're the Class A members. So in the governing documents that I draft for a developer client, we have a declarant, we have what's called the Class B control period. That's the period of time when the developer, the declarant, is actively developing, and they're going to be in control of the association. They're going to be in control of design review. If you're familiar with an architectural review committee system or design review board, we're going to state upfront before anybody ever buys in the neighborhood, look, the developer is going to control all of this until essentially they decide they're not going to control anymore. And if you're fine with that kind of system, then feel free to buy a lot or buy a house. And those systems are fixed and in place when people buy or build their home. And then at some point, again, it's built into the system that hopefully at some point, usually in lot owners' perspective, sooner rather than later, the developer sells all their lots, all of the homes are built, and they move on, and the Class B control period ends, and then we just have Class A members. So if that's what the system is for your neighborhood, and you want to know, okay, well, how long is this going to last? Well, you just have to read your covenants and see what the language says. There are some sets of covenants that will provide the Class B member has 3-to-1 votes to the Class A members. I've read some covenants that provide 100-to-1 votes. If you have covenants that specify this 3-to-1 voting, there's a couple of things to pay attention to. One, the 3-to-1 voting almost always only applies to corporate votes. It does not apply to covenant amendments. All right, and that's an important distinction. And this is something that I'm saying as a generality. You would have to read your covenants in order to determine if that is in fact true for your neighborhood. But I read a lot of covenants, and so what I'm saying is, most of the time when I find a set of covenants that has this 3-to-1, 100-to-1 voting, it's almost always exclusively talking about corporate voting. It does not address covenant amendments. This is important because at a certain point, there are going to be sufficient lot owners to amend the covenants, depending on the amendment clause in those covenants. And it's entirely possible that depending on how the covenants are drafted, the lot A, or excuse me, the Class A lot owners could amend the covenants to remove all of that Class B language. So if you're having an issue with Class B and for whatever reason determine you need to remove that Class B, you'd be looking at a covenant amendment project, and it's simply a numbers game. But again, it's entirely determined by how the covenants are drafted. If the covenants are drafted that the Class B control period ends when the declarant says it ends, and it provides unilateral amendment rights of the covenants in the declarant until they don't own a lot anymore, well, then there's not an opportunity. That's the system that the lot owner purchased into, and you're just going to have to wait it out. So there's a question about what process has to happen to update bylaws and covenants after the builder hands over the HOA. Ours have never been updated and are outdated. So I'll modify the question just a little bit. You don't have to wait until the builder, developer, declarant hands over control of the association. So in the realm or the sphere of the HOA, we have different slices of life. One of those slices is who controls the association. Another slice would be, what do our bylaws say and do they need to be updated? And another one is, do we need to update or modify our covenants? And they're not interrelated, meaning one is not dependent on another. So it's entirely possible that developer is trucking along, selling lots, say they're at 50% sellout, and they simply recycled a set of covenants that they had used on another development, and they're an ill fit for this one. And you've got that 50% of the owners go to the developer and say, hey, look, we don't do this professionally, but we can tell these aren't going to work very well. Depending on the circumstances, depending on the developer, that may be the perfect time to update those covenants. So if you have motivated lot owners who recognize a need, and you have a developer who still owns a whole lot of lots, their one ballot counts for all of those lots. It may be really easy to amend the covenants. Or, so for example, like I mentioned in my covenants, we have the declarant retain the unilateral amendment right. So under those sets, those lot owners only have to convince the developer, the declarant, to make the amendment. And you don't even have to have a vote. The declarant just amends them. So you can do that just about any time. Now, I see you raising your hand.
Yeah, I'm the one that asked the question.
Okay, go ahead.
What do we do? The builder is no longer part of they have no vote. And we have been advised in the past, and part of the reason we haven't updated the mess that exists is that we were told that if we made changes to the bylaws and covenants, we would have to have 70% of the lot owners agree to those changes. And we would also have to have them, each lot owner sign and have it notarized that they agree to those changes.
That's entirely possible. I mean, what you're explaining or what you're describing is, I can't say it's the norm, but having a high percentage of lot owners on a notarized ballot, that is the norm for covenant amendments. They're not easy projects, and so we have a state statute, and we will talk more in depth about amendments in part 2. But we have a state statute that makes it a little bit easier. And we'll run some of those scenarios, but yeah, what you're describing, that's probably the reality. There's a question about covenants expiring. I sure hope not. I have come across a set of covenants that, sure enough, they expired on their own terms, which is one of the dumbest covenants I've ever read. I mean, think about it. You have an entire neighborhood developed based on these covenants. How big do the houses have to be? Outbuildings, weathered wood only shingle, right? And I'm making this up. I don't know what these covenants are, but those are the standard covenants. And then you have, so you build this neighborhood based on these covenants, and you have in those covenants that, okay, kind of like, you know, Cinderella at midnight, these covenants just go poof and they're gone. I mean, it's mind numbing. And so they can expire. They almost always do not expire on their own terms. Now, sometimes you'll see language in covenants that say, these covenants shall run and bind the land for 20 years, at which time they will automatically extend for an additional 10 years, and so on. That's not expiration language, that's actually continuation language. And that's almost always in the same paragraph or even the same sentence where we're going to find the 75% amendment language that you were talking about a moment ago, but oftentimes they don't expire on their own terms. If we do have a set of covenants that are going to expire, we need to be talking and planning for a covenant amendment project to take that expiration language out, because that's a bad day if your covenants go away. 2 more questions here. Is there a rule of thumb for reserves? Is it better to get a reserve study, find a company to conduct the study? So on reserves, there are companies that do reserve studies. The rule of thumb in a condominium setting, or at least for FHA approval or certification, is 10% of your annual regular assessments. That could be way overfunding. It could be way underfunding. By the way, there's a website you can go to. I'm going to go to www.cairf.org. CAIRF.org stands for Community Associations Institute Research Foundation. And if you go to that website, there will be a tab for publications. And if you go to Best Practices Report, Best Practices Reports, there is one on reserve funding. That's going to tell you everything that you need to know on reserves. And if there's still questions about reserves, then we can cover it in part 2 on Thursday. Okay, but that best practices report. In fact, there's one on transition. There's one on reserves. I think there's one on budgeting. There might be one on insurance. I haven't looked at it in a while, but those are good resources, and they're free. It's a PDF download. There's a question, why isn't there a restriction on the developers in Oklahoma that requires them to turn over control to the owners at a certain percentage sold and not at their discretion, like in other states? I can't answer that question. I don't know why our legislature has taken an approach that there isn't that statute. There are other states. There's something called the Uniform Common Interest Ownership Act, often referred to as UKIOA. That's where that 75% comes from. That's a UKIOA statute. So Colorado, Connecticut, some other states have adopted the Common Interest Ownership Act, and that has language in it about required transition. But you know, I don't know why Oklahoma has decided not to. Probably the same reason why the legislature hasn't touched our Condo Act in over 50 years. Okay. Let's talk a little, we've got about 30 minutes left, a little bit less than 30 minutes, and let's talk about enforcement. I'm not going to go into a deep dive on enforcement. We'll do that in part 2. And Darcy, I'm sorry, I completely whiffed your second question. There was a second part to that. So for very old covenants, is it possible to completely rewrite rather than amend, meeting the requirements of quorum and members in vote? Okay, so there's a couple of important things here. Yes, you can completely rewrite a set of covenants. And in fact, that sometimes is what should happen. If you have such a horrible set of covenants, then maybe you do want to completely rewrite them. In other words, jump from a really poor form to completely different structure. And that's possible through an amendment. But the second thing is, so your parenthesis says meeting the requirements of quorum of members in vote. A covenant amendment project almost always is not like a corporate vote. So most of the time, we couldn't care less about quorum. We don't care about membership. We don't consider member in good standing. So like we do for board elections, you know, so for example, it's common in bylaws that you can't vote, you can't use the common areas, you can't do this or that. If you haven't paid your dues, you're not a member in good standing. None of that applies with covenant amendment projects. The only qualification for covenant amendment projects and whether you get to vote or not is whether you're a lot owner. All right. Now, it is possible that everything that I just said completely doesn't apply if the amendment clause specifically says the covenant amendment is done like a corporate vote. You see that more often in condominium governing documents. It is possible to have HOA type documents that say that, but it's not very common. Almost all the time in an HOA, we're dealing with lot owner, notarized ballot, don't care about quorum. All right. Okay, so let's talk about covenant enforcement. I won't stay on the soapbox, but I'll mention it again. The best covenant enforcement, whether it's a structural use restriction or collecting assessments, is the one that you don't ever have to talk to a lawyer about, because it saves time, saves money, and it means you've resolved the issue without it getting escalated. But if you do have to escalate, in other words, escalate not aggression, but escalate to another level of enforcement, you know, covenants are enforceable. And that's what we're going to talk about. Before we talk about that, though, I've got a great picture that illustrates why, before we slip into, you know, red lens mode or scorched earth or whatever you want to call it, there has to be someone, whether it's the lawyer, whether it's a board member, but someone has to ask the question, okay, have we considered all the possibilities here? Is there something possibly going on that this isn't an enforcement? Do we need to have a conversation with them directly? Is there a reason not to escalate it? All right, and this picture illustrates it. So it's really easy to get on the bandwagon sometimes and have a singular focus. I am horribly guilty of this. I get an idea in my head and I forget what the brain scientists call it, but it's tunnel vision, it's confirmation bias or something like that. You know, I see this guy and all I see is a guy with a great haircut, number one, but number two, doing something vulgar to me, and now it's time to go at it, right? And then I find out later, well, I had a poor perspective. I won't go into a story. I've got a great story where I embarrassed my 7-year-old daughter one time because I completely misread a situation, but it was like this picture. So we need one person on a board. By the way, this is why we have boards and not dictatorships. Imagine what our HOAs would be like if one person made all the decisions, and that person was me. I mean, I would just be seeing this all of the time and not promoting much community. So we have boards, and if possible, we like a lot of diversity on our boards. If for any reason, so that we have people who tend to see the world like this and know how to deal with people, if that is the reality, we need those people on our boards. But we also need people on our boards who their first inclination is, I don't think that's right. There's something else about this. Can we think about it a different way? That's why having diversity on boards, however that looks for your neighborhood, without defining diversity, this is a good result of that diversity. All right, so let's talk about how we move through conflict resolution. And we've already covered this first bullet: clear, upfront communication and room for honest disagreement. That's that picture, right? Conflict happens because people see things differently, because of limited resources, because of different wants or needs. It's not the fact that there's disagreement or that there's conflict. That in and of itself is not bad, although a lot of us are raised or taught or just conditioned to think that, well, if people are disagreeing, then somebody's mad and it's bad. No, that's a condition of breathing and being alive, and the fact that there's somebody else in the room with you or somebody, you know, you're interacting, you're going to have conflict. That's just relationships. Having a structure, having a mechanism, even if that mechanism is, hey, can you come to a board meeting? Let's talk about this. Or, hey, we're getting complaints about such and such. Can I come over and talk to you about this? You know, having avenues, giving opportunities to resolve or remove the conflict. That's conflict resolution. You know, all of this, whether it's, well, we're just going to ignore this because this guy's just having a bad day and he's going to get out of the system and then we're all going to go back to normal. Sometimes that's an appropriate conflict resolution. On to, we're going to hire a lawyer, we're going to file a lawsuit for an injunction, and we're going to seek damages and all of our attorneys' fees. And those are all conflict resolution. So one of the things that I want to mention is this getting ready for difficult conversations. If you think about how much time we spend practicing sports or staring at our phones, practicing this movement on our phones and just scrolling and scrolling, think about if we took a fraction of that time and practiced having difficult conversations or resolving conflict, the level of customer service or the level of hominess or communities that our neighborhoods could have. This isn't pie in the sky stuff. This is from a guy who makes his living, you know, selling my time in 6-minute increments in court. I mean, I'm happy to have the business, but the neighborhoods that I represent and have for years and decades that are really good at this, they don't call me very much. And I know as counsel, if they are calling me, that the file or the case or the conflict, it's been packaged in a way that makes my job easier. It makes it easier from an evidentiary standpoint. I know I don't have to deal with trying to shore up possible arbitrary and capriciousness or discrimination or anything like that. Those boards that have it down as far as difficult conversations go, they resolve more conflict. So after that, we have informal mediation. One of the informal mediation would be inviting the individual to come to a board meeting to present their case, to explain their side, to ask for some kind of exception or additional time, depending on what the issues are. Oftentimes we see this with collections. So my firm does a significant amount of collections in the HOA condo realm. That's all our firm does is HOA law. So all of the collections that we do is in an HOA context, and routinely you see boards waiving the penalty interest that's provided for in covenants in exchange for owners paying the amount due. And this is a reflection of the reality that the purpose of the association isn't to exact every single dollar that the covenants provide for. In other words, the amount of dues and penalty interest. Boards looking at penalty interest as incentive in order for people to get the money in, the principal amount, they have less collections cases. They have less court time, less attorney's fees. Those boards that send a file to us and tell us there will be no deals, we will make no payment arrangements, we're not cutting anything off the account statement. Those are the ones that we really have to watch the accounting. Those are the ones that have this made up $25 late fee that is just flat illegal debt. Sometimes the managers will put $25 late fees on accounts when the covenants don't allow for it. We can't collect that. And it doesn't matter how late this person is or how mad the board is or the affront at this person not paying their dues on time. Those associations go to court and they pay attorney's fees. And sometimes they collect everything that they're owed and sometimes they don't. But having mechanisms for informal conflict resolution, it's a good idea for the board to think about. We've got a couple of comments. Let's see. Do additions to bylaws that will be voted on by the neighborhood members need to be written up by a lawyer before the members vote on the bylaw addition? This is like taking your car to a mechanic and asking, is there something you could fix on my car? The answer is always yes. You should always hire a lawyer. But there's something in this that I want to make clear. So bylaws deal with the business of the corporation. Covenants deal with what you can and can't do with your property. They are not synonymous, okay? Bylaws can be filed with the county clerk's office, often are not. Covenants have to be filed with the county clerk's office in order to be valid, right? So this is important when we get to the amendment question. So bylaws, you don't have to have a notarized ballot in order to adopt them. The board, and we'll get to this next Thursday in part 2. Bylaws can be unilaterally amended by boards. They don't require a vote of the membership. Covenants do have to be voted on by the lot owners. But to your question, you don't need a lawyer to draft up this a covenant amendment or bylaw amendments, but I can tell you those neighborhoods that don't hire a lawyer, they often have to redo the process because they haven't gotten the procedure right, particularly when it comes to covenant amendments. And two, depending on who drafted the language, it may not be workable. So there are ideas that people have that they want for their neighborhood. So for example, decorations, they have an idea that, well, we need to put some kind of restrictions on decorations. And so now they talk about holiday decorations shall be put out no more than 2 weeks before and 2 weeks after. Well, what holidays are you talking about? The idea that your holidays are the same holidays as mine, that's an assumption that's not reality. So it helps having someone who has at least drafted the language before, possibly litigated the language before, not just finding any old live breathing lawyer to help you draft it up. So do bylaw changes have to be voted on by the members? Same question. Bylaws do not have to be voted on by the members. A board of directors can unilaterally amend bylaws. But again, I want to make sure everyone's clear. Bylaws are not covenants. Covenants are not bylaws. You could find bylaws tucked into covenants and filed with the county clerk, but that doesn't make them covenants necessarily. So you don't have to have a lawyer, but if you do hire a lawyer, you would rely on them to at least get it right. All right, so other forms of non-judicial remedies, meaning how are we going to resolve this conflict outside of court? There's formal mediation where you hire a third-party neutral. There's also binding arbitration. There are some covenant sets that contain arbitration clauses. It's not all that common, but you would need to look and see if your covenants have arbitration. You may have to do that as opposed to filing a lawsuit if you need to enforce them. All right, we are running to the end of our time. We talked a little bit about records. So if you want to go to OSCN and look at 1065, that'll be helpful to read through the procedure and see. One of the things that people misunderstand about section 1065 is the 5-day response. So there's a 5-day response clause in that statute, but it's not a 5-day production requirement. It's a 5-day response. So the difference is, say you get a proper formal 1065 request, meaning it states their name, their address, the purpose. By the way, proper purpose is just about anything. A proper purpose would be, I'm a lot owner, I think you're stealing our money, and I want to look at the books and records to conclusively prove that you are stealing our money. That is a proper purpose. It may be a disagreeable and a flat out wrong-headed purpose, but it's proper under the statute. And then it has to be notarized, has to be stated under oath. So if that comes in, the association has 5 days to respond, and that response can be within 5 days. We got your statutory request. We're going to work on it. Let us know if we can just make copies and send them to you. Can we just email them, or do you actually want to physically inspect and identify copies? So that would be a proper response under 1065. So don't let someone say, aha, I got you. You didn't produce what I asked for within 5 days. That's not what the statute requires. Okay. I cite some other statutes. This is it on community association records. 1065, 1069, and then 521, which only applies to condos. There are no standards, requirements for record keeping for homeowners associations. And the other place to look, and we mentioned this, is if the governing documents, more than likely in the bylaws, have a record section, then of course you would have to comply with whatever that says. I mentioned this, I want to mention again, because it's a really easy way to organize for not only for customer service, but also to diffuse a really common technique that people who are angry use in order to try to run boards ragged, in order to make them jump through hoops, and that's records requests. Okay, you can, and this goes back to that bullet about organizing or designing systems, processes, conversations to resolve conflicts. In our office, we call it running them into the corner, and it's either a dead end or you run them into the corner and you stomp it to death, whatever you need to do in that corner. But having all of your books and records in electronic format, it makes responding to records requests so much easier. And it really takes the wind out of people's sails. If what they want to do is make you work, okay, you made me lift a finger, literally, and tap it on a mouse. There you go. There's your books and records. And you know, the idea is, look, you're not going to catch us in a misstep. You're not going to catch us being disorganized. We've thought about this. We're organized to handle this, whether it's a legitimate or an illegitimate request. Here's your books and records. So it's a good practice to get into. Okay, this is my last slide. Actually, there's a comment that, okay. This is my last slide, and then we'll wrap it up until we reconvene on Thursday. Anna, did you notice I didn't say next week, not once this time?
You did amazing.
I'm so proud of myself. Everyone else, we did these for so many years, and we would have one on one week and then one on the following week that is just kind of muscle memory. I would always say, well, next week when we talk about this, but I didn't do it this time. Okay, so let's talk real quickly about some of the things that I have. I call them myths. These are things that I hear repeatedly. And it's usually someone who just, they have their facts wrong. It sounds right in their head, but it doesn't really work that way, or they've gotten some bad information from a brother-in-law or something on the internet. So oftentimes people think, well, if the board doesn't do what I say, particularly with a covenant enforcement issue, then I'm going to sue the board, I'm going to sue the association. It is possible, I mean, meaning they can hire a lawyer, they could functionally file the lawsuit against the association for that. It's just not going to go anywhere. I mean, the board does not have the affirmative duty to file a lawsuit, to take any enforcement action just because a lot owner demands it or expects it. Okay, that's not how covenants work. The board is vested with exercising discretion. And so the fact that there is a covenant violation that's going on, and it can be an actual legitimate real covenant violation, but if it's going on in a pocket of the neighborhood that only affects one other person, the board could exercise its discretion lawfully, legitimately, and say, we're not going to spend any money on that. We're going to spend $5,000 on flowers for the entrance that affects more people than $15,000, $20,000 on a lawsuit that's tucked in this corner. That is a legitimate business decision of that board. All right. The same thing with plant more trees in the common area or else, or the trees in the common area behind my house died, replant them or I'm going to sue the association. Nope, doesn't work that way. All right. That's like saying, board, you better plant petunias in the flower bed at the entrance as opposed to daylilies, or I'm going to sue you. Okay, you could do that. I'm sure there's a lawyer out there that'll take your money to do that, but it's just not going to go anywhere, right? The board does not have to follow your every whim. All right, we'll cover some of these others, particularly the lien and foreclosure in part 2 on Thursday. Anna, thanks for hosting and good seeing you. I will turn my mic off.
Well, thank you, Matthew. Thank you, everyone, for spending the last 2 hours learning about how to be even better leaders in your HOA. And we appreciate you all engaging and asking questions. And we look forward to seeing you all Thursday evening. Again, use the same link. I'm sure we'll send another reminder, but it will be the same link Thursday, 6 to 8 p.m. Hope you all have a great evening.